Hello, everyone. My name is Kambiz Ranavardi, co-president of ColumbiaDC and a graduate of School of Engineering and Applied Science. Let me take this opportunity to thank our partners, MIT Club of Washington, D.C., and their members for joining us this evening. We are so honored to have John F. Banzhaf III, professor of public interest law at George Washington University Law School, to discuss the concept of legal activism and how it differs from public interest law. And he will do that as an extension of his storied and exciting life story. So please allow me to briefly introduce our speaker. I do encourage everyone, however, to check our site to see his full bio and references to his incredible body of work. John F. Banzhaf III is a nationally known professor and practitioner of public interest law. Professor Banzhaf teaches torts, administrative law, disabled people and the law, law and the deaf, and a unique world-famous course called Legal Activism, where students learn to become public interest lawyers by bringing their own legal actions. Professor Banzhaf received his undergraduate degree in electrical engineering from MIT and for a time worked as a scientist and an engineer, writing several published technical papers and obtaining 2 US patents. At Columbia Law School, he was an editor of the Law Review and obtained the first copyright ever registered on a computer program and helped persuade Congress to amend the copyright statute to include data processing. Professor Banzhaf serves as the playing faculty advisor for the George Washington University Volleyball Club and as a fellow of the World Technology Network. Without further ado, Professor Banzhaf, please take it away.
Good evening, ladies and gentlemen. As the man said, my name is John Banzhaf. I'm a professor of public interest law at George Washington University here in Washington, D.C., sometimes known, at least to us insiders, as Disneyland on the Potomac. That's Fantasyland at one end of Pennsylvania Avenue and the Magic Kingdom at the other. And by the way, it's still the only city in the U.S. which has a 5-day waiting period to buy a member of Congress. So yes, I'm both a lawyer and a law professor. And while I'm sure that you've heard many lawyer jokes, raise your hand if you know any law professor jokes. No, that's kind of what I thought. So let me give you one. What do you get when you cross a law professor with a mafia don? The answer is an offer you can't refuse or understand. Well, this evening, I'm going to try to make you an offer, one which I think you hopefully will not refuse, but certainly you will understand, one to join me and others in being an activist. So if you will please excuse my COVID haircut, or I guess I should say COVID non-haircut, and these virtual books on the virtual bookshelf behind me, in our brief time together, what I'd like to do is to do 4 things. 1 is to explain what a legal activist is. 2, to explain how and why I kind of unexpectedly became one. I call it my Odyssey from Geek to Gigolo to good Doer. 3rd, to describe how all this led to my unique law school course. It's called formally Legal Activism. The students call it Sue the Bastards. Some of them call it Suing for Law School Grade. And 4, probably the most major part here, is to show you how effective legal action and the use of law generally can be. And not only by just lawyers or just law students, but also by others, especially those of you who are, like me, in academia. So as a professor, let me begin with a definition. What is legal activism? Well, the concept of law, as most of us teach it in law schools, and most of you learned it if you're a lawyer now, is that law is a method or a technique for resolving disputes between individual entities. Could be individuals, corporations, trusts, the government, etc. But the key idea is that there is an identified individual. He or it has a problem, actual or prospective, and your job as a lawyer is to use the law to help solve or resolve the problem. The legal activist says, yeah, that's fine. But in addition to that, law can be, should be, a very powerful, underutilized weapon for social change, to change things, to go after a problem. And that problem could be environmental protection or obesity or smoking or domestic violence or all different kinds of things. So the legal activist is one who doesn't have an identified client usually, but rather looks out and says, I want to do something about problem X. In my case, is smoking. What kind of legal actions can I bring which will do that? It's sometimes linked to the motto which is associated with me and legal activism, which is called sue the bastards. You could think of that in one of two ways, depending upon how you emphasize it. You can emphasize the first word, sue the bastards, meaning that often the best way, sometimes the only way, to accomplish real change, particularly against a major opponent, is to take legal action, to sue. On the other hand, you could put the emphasis here, sue the bastards, by which we mean that for us lawyers, we who will spend our lifetime suing or threatening to sue or defending suits, isn't it better that you go after the bad guys, the people who deserve it, rather than let your defendant or respondent depend upon who happens to be walking into your office with a retainer? So to help put that in context, I'm going to try to explain to you how I became a legal activist, which was really a very transformative experience for me. I started at MIT. I was a geek. I was interested in science and engineering. I got my brass rat back in 1972. And quite frankly, I was rather blasé about all the problems in the world at that time, whether it was the war or civil rights or these other movements. Nothing much happened at MIT, which is unusual. I think like most of my classmates, I did my share of hacking. And so maybe I'm one of the oldest living hackers, I don't know. But I did write a piece for the MIT Voodoo magazine, or humor magazine. It was an article about Murphy's Law, and it happened to mention foo. And I was surprised to find recently that people are claiming that, in part, I was responsible for the fact that so many programmers use foo when they write. In any case, I did well, got 2 US patents, half a dozen technical papers, but I wasn't quite satisfied. I didn't like the idea of spending the rest of my life fixing a component to work in a subcomponent to work in somebody else's system. And so I decided to try my luck at going to law school. And I went into Columbia Law School, became an editor of the Law Review. And again, nothing particularly unusual, except for 2 things, which might have been harbingers for what was to happen, although I certainly didn't realize it at the time. First, in my second year, I had to write an article for our Columbia Law Review. And because I had a technical background, I chose computer programs. More specifically, to find out whether it was possible to provide legal protection for computer programs by getting them copyrighted. At that time, there was a strong legal precedent saying it couldn't be done, and I decided to look into it. And so I wrote this article, and I came up with what I thought was a pretty ingenious argument as to why computer programs should be copyrightable and the copyrights registered. But then it just something struck me. I said, why should I just write an article explaining what I thought were wonderful arguments? Why don't I go ahead and try it? And so since I had learned a little bit of programming at MIT, I wrote a couple of programs, hopped on a bus, went down to Washington, D.C., met with the head of the Copyright Office, and believe it or not, she agreed to permit me to copyright or to register the copyrights on my computer programs. That was a major breakthrough. I mean, even today, they're fighting in the Supreme Court over the scope of computer program patents. In any event, I followed it up with testimony before Congress, explaining why the copyright law had to be revised in order to take account of computers and data processing and so on. And they passed that, and the law has changed. Second thing that happened to me at Columbia was I was asked to write an article about weighted voting and whether or not it worked mathematically. I did the math, again, using my MIT background, and I concluded that it didn't work. And so I wrote an article saying, one man, one vote, basically that it doesn't work. And that got published. This was just after the Supreme Court's one-man, one-vote decision in 1964. In order to prove that it didn't work, I had to basically invent a new kind of mathematics. Today they call it the Banzhaf Index. It's taught all across the country in most colleges and many high schools. I used it to show the New York's highest court, the Court of Appeals, that weighted voting didn't work. I later went on to use it to analyze the Electoral College. And looking back, those two weren't what I would call activist activities, but they did show a kind of an inclination, even though I was still totally unconcerned about various things going on, to take action rather than just to sit back or just to write about something. When I left law school, I clerked for a year, and then I started working as a gigolo. Now, let me define that term for you. The word gigolo comes from the word jig. A gigolo is a man who was paid to dance a jig with women. And so basically, I got a job on a cruise ship where my major job was dancing with women. It allowed me to go around and see the world at a time when it was very, very expensive for anybody to travel, but that was the way I was able to travel, and I had an awful lot of fun working as a gigolo on a cruise ship. Well, I became interested one day. I was watching television with my father, and we happened to see a lot of cigarette commercials. Indeed, you couldn't avoid them. They're the most popular product then advertised on television. And something occurred to me, something called the Fairness Doctrine, which I had learned about, which said that if broadcasters present one side of a controversial issue of public importance, they're required to present some time, free time, for the other side also. And so one night, sitting in the purser's office of a cruise ship just before we're about to go on a 92-day round-the-world cruise, I wrote off a brief 3-page letter, dropped it in the mail right at the pier there with an 8% stamp, and I sent it to the FCC, and I argued that every broadcaster that broadcasts cigarette commercials should be required to provide free time to the other side. Much to my surprise, amazement really, when I came back, I'd done one other cruise. I joined a law firm, a major patent, copyright, trademark law firm, and much to my surprise, the FCC agreed with me. They issued their ruling Friday afternoon, so it wouldn't upset the stock market. And as it was announced, somebody asked whether 3-to-1, 3 cigarette commercials equal 1 anti-smoking message, would that be fair? The FCC chief counsel said yes. That kind of became a guide mark or a guideline for the ratio which was going to be used in the future. And so the decision came down, but it was certain to be challenged by the best lawyers in the broadcasting industry and also obviously from the tobacco industry. When I came in that Monday following the announcement, I was called into the office of the senior partner who explained to me very quickly that our major client was Philip Morris, and if I continued in this vein, working on this decision, I probably wouldn't make partner. And so what I did is I went to the major health organizations, the Heart Association, the Lung Association, the Cancer Society, and I said to them, you're getting all this free time, your messages are on the air, this is going to be attacked by the very best lawyers that money can buy. I'm fresh out of law school. I can't do it. Please defend it. They all refused. And so over the summer, it was challenged, in fact, and I had to decide whether or not I would stand up for it, defend that ruling, because if I didn't, I was pretty sure it would not stand, and possibly, then almost certainly, lose my job, or whether I would go ahead and defend it and probably have to do something else. And it was a rather stark choice. Remain a fat cat patent attorney, very lucrative career for somebody with an MIT degree, or go out and defend the decision and leave that all behind. I made that hard choice. I never regretted it, never looked back. So one of the things I did was, after I left the firm, is I started a new organization called Action on Smoking Health. And it was dedicated to a new and novel idea at the time, that you can have an organization which uses legal action to attack a societal problem. This was a completely new concept. The idea of a legal action organization hadn't really been heard of. Today, of course, we have many of them. Environmental organizations, women's rights, LGBT, other organizations which primarily use legal action to go after these problems. But at the time I formed ASH, it was a dream, it was an idea. I had no idea whether it would work, but we did it. And again, the organization was tremendously successful. We went on to do lots and lots of things with regard to smoking, many victories that you probably have seen, but we'll leave that for another lecture. One of the other things I did is I started teaching law at George Washington University, and I decided to start and to teach an entirely new course, which I called legal activism. I developed it, I guess, for two reasons. Number one is, at that time, when I graduated from Columbia, like most other law students, we had no idea what the real world of law was. We had never, most of us, ever been in a courtroom, seen a court argument on television or anywhere else. We had never seen any real legal papers. It was all totally theoretical. To me, that's crazy. That's like having a doctor do an appendix because he got 95 on a theoretical exam about how to take out an appendix. The other is, when I made that decision, it was a transformative decision for me. And I wanted my law students to have that same opportunity, to use their legal skills, not just to protect or represent a client, to advance their interests, but rather to use it to do something, to advance a cause or to attack a problem that they are sincerely interested in, and then to get this wonderful, unbelievable feedback when you are successful. Now, by the way, this probably was the first time clinical law was actually introduced to a law school. And indeed, several years later, when I came up for tenure, I was denied tenure because, well, it was too radical an idea. Actually having students do something real just wasn't proper. We are a professional school, my colleagues said. We're not a trade school. So I was denied tenure until that decision got reversed. Today, of course, as all you lawyers know, so-called clinical law or experiential courses are required in all law schools. They're usually limited to clinics. Mine, of course, went above and beyond various clinics. So, with that as a background, and I guess a warning of what's to come, let me tell you something about the legal activism projects that my students put together. Not, of course, to brag, because like most law professors, I'm pretty modest and humble. In fact, I'm known around the world for my modesty and my humbleness. Oh, that reminds me. There's another lawyer joke. Put up your hand if you've heard this one. How many law professors does it take to change a light bulb? Okay, nobody seems to know. The answer is only one. You take a light bulb, hold it up like this, and the world, of course, revolves around us because we're law professors. So if I move it away, you see what happens with a virtual background. So, the reason I'm telling you all of these tales about what our law students have done is hopefully to inspire you, maybe challenge you, because all of these were done by second-year law students at a good but not necessarily very top law school. They did it in addition to all their other courses. They did it in addition to their outside work. They did it with their limited knowledge. They were second-year law students. And at that time, we had no internet, no research, no printers, pretty hard times. And so what I'm hoping is that this will somewhat encourage you to join us in suing the bastards, to perhaps think outside your ordinary box. And like many of my legal activism students, think about becoming an activist. Oh, by the way, many of these groups have kind of funny acronym names. And the reason they have them is because it helps us to get publicity. And so we did get a lot of publicity. The media called them Banzhaf's Bandits, like Nader's Raiders, those of you who remember back then. And publicity is a very powerful weapon in the arsenal of any legal activist or public interest lawyer, along with legal activism techniques like legal leverage, legal judo, guerrilla law, and so on. So let me jump right into a little bit more than half a dozen of these projects, give you some background, explain what was going on. First one, probably the most effective one all over, was a group called CRASH, Citizens to Restrict Airline Smoking Hazards. Began back in 1969. The world was just beginning to be concerned about outdoor air pollution. And people began wondering, well, how about indoor air pollution? We thought it might be dangerous. We had no idea at that time that in many ways it is far more dangerous than outdoor air. So we decided to bring a project to test this, and we chose airlines because by law, they owe a very high standard of care to their passengers. And secondly, unlike virtually every other place, like a doctor's office or a hospital or a mall, if you get surrounded by tobacco smoke, you can't step outside for a breath of fresh air. And so the law students petitioned, the agency at the time was called the CAB, Civil Aeronautic Board, no longer exists, and they said, you want to require separate sections, smoking and no smoking sections. That was a radical idea at the time. It couldn't possibly have been achieved by going to Congress. There's little public pressure for it, but it's a good illustration, I think, of the tremendous power of legal action. So they filed what we call a petition for rulemaking, asking the agency to adopt, to promulgate a rule saying that airlines had to provide separate smoking and no smoking sections. Well, they did. And just that small step caused people to change their perceptions in very important ways. Number one, the people who flew, and this included many influential people at the time, more so than today because the prices were so high, they learned that most people don't smoke. Most people, I think, at that time thought most adults smoke. Secondly, they found that a mere separation wasn't perfect, but it helped. It was a hell of a lot better than sitting next to somebody or being surrounded on both sides by somebody who's smoking. Third, separating smokers and non-smokers didn't create a really big problem. So we were able to expand it. We got them to crack down on drifting tobacco smoke, ban pipe and cigar smoking, etc. And then we went for a ban on smoking, total ban on flights of 2 hours or less. And to show you just how hard that was, the American Heart Association and the American Cancer Society, among many others, opposed it. They argued people have a right to smoke even on an airplane. Well, we finally were able to achieve it. No smoking on airplanes today, thank goodness. Meanwhile, the whole idea spread to the ground, and we began to see legislation setting up and requiring so-called no smoking sections. But let's be realistic. The no smoking section of an airline or of a mall or of a hospital or a doctor's office is about as effective as the no peeing section of a swimming pool. It doesn't work because things tend to drift. And so we fought again. And today, of course, as a result of this initial decision by law students, initial project by law students, we have bans on smoking indoors all around the world, both here and abroad. We have bans in many outdoor areas. My university is one example. We have many smoking bans, even in private homes and apartments. And so this little petition by several law students in their second year, on top of everything else they were doing, led to a major public health movement. And today, most experts agree, it is this movement which is the most effective way of getting people to quit or not to start. The smokers repeatedly say they got sick of being treated like a pariah by having these no smoking sections. No smoking sign is a constant reminder. Unlike the ads they were still seeing in magazines, for example, saying that smoking made you sexy and sophisticated and sociable, actually it made you stinky and smelly. People didn't want to be around you, and that's why people quit. Second group is called SCRAP. This case that went all the way to the Supreme Court. It's called Students Concerned About Regulatory Agency Proceedings. Background, time is 1972. Supreme Court had just come down with a very famous, infamous decision known as the Sierra Club case. In that case, the Sierra Club sued, trying to stop what they saw as a major environmental harm out in Ninking Valley in California. The Supreme Court threw out the case, saying the Sierra Club, the mighty Sierra Club, the well-known, most well-known organization protecting the environment had no legal standing. They could not go into court to protect the environment against harm. And that was treated by gasps of outrage. Editorials in the New York Times, the Washington Post, and elsewhere basically predicted environmental litigation was almost dead. If the Sierra Club couldn't get legal standing to bring these actions, who could possibly do it? Well, in the meantime, we have a new statute called the National Environmental Policy Act. We now call it NEPA. And what it said is that before somebody engaged in a major activity which had a significant effect on the environment, they had to do an environmental impact assessment and report. And the students started their project, and it had only been applied to, forgive the pun, concrete projects, buildings, airports, roads, etc., etc. Nothing ephemeral. It turned out that the students found that railroads largely set their own rates for various different kinds of freights. And for a variety of reasons, it typically would cost 2 to 4 times as much to ship a ton of recycled material as it would cost to ship non-recycled material. This had been challenged by the various trade groups who were active in this area, but they always lost because they argued that it wasn't reasonable, that it wasn't fair, etc. That was a losing argument. And so the students came up with a new argument. What they said is NEPA applies even to rate setting, not a concrete project, but to setting of rates, because those rates have a significant impact on the environment. They discourage recycling. They encourage digging and chopping and cutting down of various natural resources. And so the students had to go to eventually went to the Supreme Court, and to make that argument, they had to establish that they, unlike the Sierra Club, had legal standing. Through a series of, I think, kind of ingenious arguments, they achieved that. Indeed, there's a famous line from the Supreme Court decision, for those lawyers who've read it. It says, legal pleadings must be more than an academic exercise. Yet that's exactly what this was, and the Solicitor General was all upset and conveyed that to the Supreme Court, that this was just a class project for which they were getting a grade. Well, this was a major breakthrough for environmental litigation, environmental protection, and I'm kind of happy that we were able to do it. Third group is called BLAST, Black Legal Action for Soul in Television. Time is the early 1970s. District of Columbia is a largely black city, much higher percentage of African-American citizens than it has today. And yet, of all of our major TV stations in the district, not a single one had ever had an African-American on-the-air TV reporter. Indeed, so far as I know, no major TV station anywhere in the country, regardless of the audience, had had a black reporter on the air. And so the students decided to challenge this. They put together a petition opposing the renewal of the license of one of our major stations. I will tell you quite frankly, it wasn't a very good petition. I can tell you for sure it wasn't even a very long one, and the reason I know is the 3 typists who had volunteered to come in and type it over a long Labor Day weekend, none of them showed up. I had to type the whole goddamn thing. I mean, typing at a time when you used a typewriter, if you made a mistake, you typed the page over. God help you if you had to slip in something new after the proofreading. Well, in any case, they filed it. And within a very short period of time, 3 things happened at that station. Number one, they put a black reporter on the air for the first time, so far as we know, anywhere in the country. They put a black person as a host of one of their locally originated programs. And they doubled the number of black executives. Well, to 2, but it's progress. Well, soon the idea was picked up. It went all across the country. Other blacks picked it up. Hispanics picked it up. Women did it, and so on. Eventually, we lost for technical reasons, But that's a good illustration that sometimes you can win the battle, or win the war, even though you might lose the battle. We didn't win the case, but we sure as hell changed literally the face of TV. Fourth project, didn't have a fancy name. We sued McDonald's. McDonald's at that time was advertising their French fries, quote, cooked in 100% pure vegetable oil. I had a few vegans in the class, and they were delighted with that. They were eating French fries because they thought it didn't contain any beef fat. And then they were outraged to learn something. That, yeah, technically, it wasn't a lie, it was true. They were cooked in 100% pure vegetable oil. But what they didn't tell people is that they were pre-cooked in beef fat. And so these vegans went out and put together a lawsuit against the mighty McDonald's, arguing that this was deception by failure to disclose. You can tell the truth, the literal truth, but if you don't disclose a key fact, that's still deception. Well, everybody thought this suit was frivolous. You know, who cares? No harm. Bunch of law students. Mighty McDonald's. Well, mighty McDonald's wound up paying $12.5 million to settle it, plus attorney's fees. They had to correct their misrepresentation. They had to publish a public apology. And that lawsuit, by the way, has started what we now call the fat lawsuit movement. We're using legal action as a weapon against obesity, just as I used it so successfully against smoking. I wound up in the movie I inspired, Super Size Me. I helped defeat a so-called cheeseburger bill in Congress. And believe it or not, a lot of people were critical of us. They said my law students and I were picking on poor little McDonald's. Fifth one is the Agnew lawsuit. Agnew, you remember, was our former vice president. He resigned in 1973, pled guilty, but he wasn't required to give back any of the money that he took in bribes. My law students were upset. Why shouldn't he have to give back the money? Shouldn't a high public official be held to an even higher standard? And so they came up with a very interesting legal theory called principal and agent. If an agent accepts a bribe, the principal should be able to sue the agent and recover that bribe. Because number one, the agent certainly should not be able to keep it. Secondly, if the agent received, for example, $50,000, he's probably harming his master, his principal, much more than that. So the principal ought to collect the money. And armed with that theory, we hopped in my old Volvo. We drove out to Annapolis. We met with the governor then, Marvin Mandel, and tried to convince him to bring the cause of action, the lawsuit against Agnew, but he refused. We could not understand why. We were very deep. Does anybody have any idea why? Just raise your hand. Right? If you don't, the answer is, we learned later, Marvin Mandel, the then governor, was also on the take. He didn't want to establish that kind of adverse precedent. And so the students came back dejected. I sent them back into the law library. I said, dig a little deeper. They came up with a new legal theory, which is actually the cause of action, called qui tam. Nobody had heard of it since the 16th century. They were able to bring it in Maryland. We were able to use it to force Agnew to pay back all the money he had received in bribes, plus interest. And I've got a copy of the check in my office to this day. Sixth action, or sixth project, is SOUP, Students Opposed to Unfair Practices. We used a kind of a dumb case at the Federal Trade Commission to get the agency to agree that it had the power to adopt corrective advertising. Up to that point, if they caught a company engaged in deceptive practice, they tell them not to do it. What they call this go and sin no more order. Well, what the hell good is that? It doesn't deter. And by the time they get the order in place, they probably changed they've gone into some new kind of ad procedure. So the students went into this proceeding involving Campbell's Soup, and they were able to convince the Federal Trade Commission that it had the power to order this corrective advertising, although they didn't decide to do it in that case. First major victory. Secondly, a new case came up. A tire company insisted that its tires were rounder than everybody else's. A little nutty, but a lot of people were apparently deceived. The strange thing here is the students went in again to argue for corrective advertising. and the major advertising organization in America, the American Association of Advertising Agencies, came in with two unbelievable arguments. They said to the FTC, first, nobody believes ads anyway. Secondly, even if they believe them, they don't remember them. And so the students, in order to counteract that, had to hire an expert who came in and said basically that was all baloney. Again, the FTC agreed that they could establish corrective advertising, impose corrective advertising. And interestingly enough, here, students established two new precedents. Number one, that public interest groups such as they could intervene, could become a part of this kind of consent decree proceeding. And then more importantly, perhaps, in appropriate cases, you can force the government to go and pay for your attorney's fees. And I'm happy to wind up on this one by letting you know that one of the most famous examples where corrective advertising is now in effect involves my old friends or enemies, the tobacco industry. I had originally suggested to the government many years ago and provided a legal analysis that they bring a RICO action against the tobacco industry. Racketeering, influence, corrupt organization suit. The government did, they won, and one of the remedies is corrective advertising. And so the tobacco industry, the various tobacco companies, now have to, or at least for a while, had to run ads explaining how in the past they had deceived the public. That's deterrence. That also helps to overcome the deception that the public received. Let's see, number 7 is coming up, and interestingly enough, it's in the news. Well, it was yesterday. New York State just passed what they call a ban on a pink tax. That is, charging women more than men for substantially the same goods or service. Well, 20 years ago, my law students did the same thing. The group is called CADD, C-A-D-D, Coalition Against Discriminatory Dry Cleaning. What we found is that dry cleaners were charging women 3 to 5 times more to launder a shirt if a woman brought it in than if a man brought it in. Even exactly the same shirt. Exactly the same shirt. And so we brought a legal action arguing that this was illegal discrimination based upon gender under the District of Columbia Human Rights Act. The dry cleaners resisted. They argued that it cost them more to do women's shirts than men's shirts. Women's shirts were smaller, this, that, and the other thing. But in the end, we won. We got consent decrees from all the dry cleaners in the District of Columbia that they would charge the same rate as shirts brought in by men, as well as those brought in by women. They would charge the same for men's shirts as well as for women's shirts. Well, that kind of got us excited. And a year or two later, I had one of my female law students come in and complain. She said, you know, Professor Banzhaf, I've got this, relatively simple, short, man-style haircut. I don't know what else you'd call it. That was popular then. And she says, I get charged about 4 times more than my boyfriend who has exactly the same haircut. And so we put together another project, and we went in and argued that that was sex discrimination. Here, interestingly, the other side argued that they were justified. It costs more to cut women's hair than men's hair, even if it's the same haircut, because they said women are fussier. Women are fussier. And they got Bill Clinton's hair cutter to come in and testify. So we got Hillary Clinton's hair cutter to come in and say that was a load of crap. We won the case. They have to charge the same rate. We went on, by the way, to do the same thing with regard to ladies' night. Here, some people argued that why are you outlawing it? It should be legal. I mean, after all, they said it benefits women. They pay less. It benefits men. They get women into the bar. But we were able to successfully argue that it constitutes illegal sex discrimination, even though it may be favored by cheap women and horny men. Okay, before I get to the last one, number 8, let me just mention that not all of the kind of public interest stuff that I do involves the law students. I do some of these on my own. Some might say it's a little bit of a hobby. And just to give you an example or two, one day I was sitting around reading a newspaper, and I saw that the the Department of Human Rights had gone after the Cosmos Club, a very famous club in D.C. For people, members who have achieved distinction in the arts and sciences. Oh yeah, but by the way, you have to have a penis. And so I challenged that on the basis of sex discrimination, but I had nothing else to do that day. And we won that case. Now all men's clubs virtually are, well, most of them are now gone. I did a similar thing with the Citadel. The Citadel was refusing to admit women as cadets. They were state supported. And so I filed a complaint there. And in the end, they were forced to admit a woman, the first woman ever admitted to one of those state-supported military schools. I'm also called the father of potty parity. Oh, you don't know what potty parity is? Well, those out there who are female probably recognize that in most public places, when there's a break between sporting events or the Act 1 and Act 2, and everybody races to the restroom, the women wind up standing on much longer lines than the men do, and that's not fair. And so I was able to argue that this was a form of illegal sex discrimination. Potty parity aimed at eliminating that. That is, putting in more fixtures, or at least an equal number of fixtures, and in many cases, New York is one example, more fixtures for women than for men, so the waiting time is more or less equalized. That's what we mean by potty parity. Oh, by the way, I filed a very interesting complaint, which finally forced our House of Representatives to establish a restroom right off the House floor for female members, so they no longer had to go traipsing and running through the halls as they did in the past. Last one I'll tell you about is a group called FAT, or Fat Labeling. They didn't have a fancy name. What happened here is there was a major study, governmental and private organizations together, about 1,000 pages. And they were looking at the cause of heart attack, and they found out that eating fatty foods was one of them. And they came up with a long list of recommendations, one of which is that we should start listing the fat content of foods on the cans and other prepared foods that you get in the supermarket. Well, like most reports and recommendations, that sat on a shelf, nothing much happened. My students got a hold of it, basically took this wonderful 1,000-page report, 1,000-page roughly report, and slapped 15 pages on it in a petition for rulemaking, asking that there be a new rule requiring the disclosure of fat. And it was successful. And so that kind of illustrates one of the points I'd like to make, which I'm trying to make to my own university, which is that if you want to have high-impact research, not just legal research, but research on fat and heart attacks, research on devices to reduce automobile accidents, or any such thing like that, one way to have high-impact research is to take the idea that would benefit the public and put it into a petition for rulemaking, asking an agency to adopt it as a requirement, as, for example, the kids in Crash did, or the FATs, or we did it with school buses, safety standards for school buses. And in that way, many of these things will become effective. They won't simply be reports that sit in some learned journal or never get read. Secondly, I'm still trying to convince my colleagues at GW about this. If you take a non-legal research project, again, it could be on heart attacks, it could be on obesity, it could be on auto safety or airline safety or anything else, and you put it into a formal legal document, then that gives you an opportunity to hold a press conference, to issue a press release, to use other techniques based upon that to bring it to the attention of the public. And that then tends to help ensure a much higher, more widespread impact far beyond that of traditional law review journals. All right, we're getting near the end. What lessons might you carry away from all of this? Well, I'll suggest 3 of them. One is that you too might have a transformative experience. Here I was, a guy an engineer turned lawyer, happy to be a fat cat pet attorney, couldn't care about all of the social movements going on at the time, and bringing one legal action, which people say saved millions of lives, billions of dollars. That was pretty heady stuff for a 26-year-old kid who just graduated from law school. It was a transformative experience. It happened to me. I suggest it might happen to you. Secondly, legal action can be a tremendously powerful and effective weapon for social change and social justice. And this is true even if you happen to think that the system may be stacked against different groups of people and so on. You don't have to be a well-connected lawyer to do it. My second-year law students did it. Law can be like the sling that helped David bring down Goliath. It equalizes the power. It gets things done which you couldn't possibly do through lobbying or organizing, whatever else. Third, as I just said, if you have a new idea, put it in the form of a legal document. It will have far more impact. So, in summary, and I think many of my colleagues are living proof. I tell my law students, you can do well by doing good. Moreover, as Spider-Man reminded us, actually it goes way back to the Bible, with great power, there's great responsibility. So those in the audience who have power, by that I mean at least all of the lawyers and many others, perhaps it's time to assume that responsibility that comes with that power. Well, as Bugs Bunny used to say, that's all, folks. I'll now to take your questions. And by the way, if I haven't made most of you think, and perhaps maybe a little bit edgy, I guess I haven't done my job. Oh, and by the way, if there aren't enough questions, there is going to be a pop quiz. Mr. Moderator, back to you. Give me the first question.
Hi, everyone. Thank you so much for joining us today. Professor Banzhaf, thank you. My name is Miyako. I'm the club administrator for the ColumbiaDC club. We did have some statements come in, so I did want to just read them before we get to the questions. We have about 3 or 4 in the queue right now. But Alex Haliaso says, he asks if you can write a book on your legal activism course.
I'm working on one. It's going to be called Suing the Bastards.
Great.
Maybe Suing the Bastards for fun and profit.
And Peter Freeman says that he took a class from you back in 1996-97, and you were his torts professor, and that he uses the word negligence every day in his transactional practice, and his indemnity clauses are so clear that they've never been litigated, and he's delighted to see you today.
Well, great. I'm delighted he's being so successful. And if I might add a word, because some of the people out there from MIT, one of the things I didn't get into is the fact that the kind of things I learned at MIT, math, science, technology, and so on, come in very, very useful in understanding law, in using law, and addressing legal problems. It's going to become more so, much more so, as we become much more technologically advanced. It turns out, by the way, that when I was at MIT, law schools wouldn't take tech people. MIT was a huge school. They didn't even have the LSAT there. I had to go all the way up to Harvard, all the way up the river, and I was dressed as my MIT guys were, in my dirty pants and my acid hole t-shirt. All these guys, yeah, they were all guys, were standing around in their 3-piece suits. They didn't want to take, at that time, they didn't think anybody who didn't have a liberal arts education could possibly succeed as a law student. Today, we know that the law school, a technical education, tremendously valuable, helps you learn the law, helps you practice the law. So some of you are out there who, like me, studied electrical engineering or physics or whatever it is, you might want to think about going over to the dark side, as my friends called it at the time. Back to you.
Great. So we have one more comment here. This is from an anonymous attendee. Says that they work in public and global health and have specifically been working with the WHO on household air pollution publication the past few months. And they just want to say how much they admire and appreciate the work you've done and continue to do. So thank you for that.
Thank you very much. Let me take this opportunity, though, to point out something which is happening right now. For me, it's deja vu all over again, as Yogi Berra used to say. Remember I told you how we fought about drifting tobacco smoke on airplanes? Well, the plane manufacturers used to tell us and try to argue to Congress, you don't need to ban smoking. We've got super HEPA filters. We've got wonderful, wonderful ventilation systems. Don't worry about it. Well, of course, everybody who was on a plane knew that that was crap, because the minute somebody lit up a cigarette, even way in the back in the smoking section, you'd smell it way up in the non-smoking section. But today they're making the same argument. We've got these wonderful filters. We've got this wonderful ventilation system. Don't worry if people are coughing and sneezing or not wearing masks, or even if they are wearing masks on the airplane, don't worry. What I'm trying to point out now is, don't bet your life on a HEPA filter on an airplane.
Okay, so we have a good number of questions coming in now. If you are still listening, type in your questions. We're going to be here for a while still. We have about 5 right now. So the first one is from V. Schwartz, and they say that you're a champion of attacking laws you believe are unfair to potential plaintiffs. Are there any rules of tort law or rules of evidence, such as the very weak Federal Rule for Evidence 702, addressing the admissibility of expert evidence, that you believe are unjust and unfair to corporate defendants? If so, which rules of tort law or evidence that fit that bill would you help eradicate such rules?
My answer in general is yes. The caller is named Victor. He and I went to law school together. We debated often and frequently. We were on different sides, but we always respected each other. And I'm glad he's watching and calling in. There are lots of things that I would change on the defense or the plaintiff side. I don't think this is the time when we have an audience which isn't completely made up of geek-like lawyers who want to debate 702 and subsection this and that and the other. Vic, I hear you.
Okay, we have a question from another anonymous attendee. Is there a go-to resource and how-to book on how to draft a petition for lawmaking?
Okay, technically it's called a petition for rulemaking. I'm reasonably sure that there are books or places on the internet where you can find it. But in addition, let me clue you into something which is pretty interesting. There is a website, it's either called regulation.gov or regulations.gov, I never remember which. And it is a relatively new website, and it lists virtually all of the regulations that the government is considering. And it puts them up there because it invites people to submit comments. Usually you have 60 or 90 days after it goes up on the board there, and you can submit comments. Now they can be legalistic comments, that's for lawyers, but they could be policy arguments. They could be scientific or technical. You could come up with a scientific or technical reason why the agency should do X and not Y, or vice versa. And I believe they actually include the petitions for rulemaking, which are there. Also, every agency has its own website. So you can go to the website of the Federal Trade Commission or the Federal Communications Commission or the Environmental Protection Administration or whatever. And they usually have something, how do you file a petition for rulemaking? And it's usually pretty simple. You give them the substance of the rule. You make the argument as to why it might be necessary, and pretty much they're supposed to take it from there. That's the whole idea of agencies, is they're supposed to do a lot of work for us. If you're a lawyer like me, sure, we can run into court day and night and we have no trouble. But if you're a physics professor and you come up with a new way, for example, of preventing high-speed train accidents, something I did, by the way, or you come up in the chemistry area and you have a great idea, you can go to the agency and say, you should adopt this. Here's a wonderful idea, you should adopt it, and that's your petition for rulemaking. So you can go there to see how to put up a petition for rulemaking. Better yet, you can go in there, use the keywords, search for rules which are already going through this process, and then you can submit your comment. I recently did that on a rule which related to how date rapes are investigated and handled on college campuses. And you might think, putting this in, there were 100, I think it was 60,000 comments. You might think they're not going to watch mine. But I was very fortunate. They adopted the 2 proposals that I made. And one of them they actually singled out publicly, and they're really quite happy about it. So I would encourage both lawyers and non-lawyers to look into this It's a great way of doing things. The whole idea of having an agency is let them do most of the work. The same thing if you've been the victim. You've been a victim of discrimination, for example. You probably can't afford to file a lawsuit. If you go in and talk to the agency which handles that, they then become your lawyer, and they've got the clout. So I would encourage people to do it. You don't have to be a lawyer to sue the bastards.
Okay, we have about 5 questions and another statement, which I'll save for later. But Gail says, would one of your law students take on banning smoking in multi-unit housing?
The answer is that's already underway. There are a number of organizations already doing that. I have been out of the anti-smoking business now for about 10 years, since I retired as head of Action on Smoking Health. But we did a lot of those. We brought actions. We used legal theories like nuisance and trespass and so on, that smoke drifts from one apartment to another. And we established these principles, and these suits are going on. I believe HUD recently put a rule into effect which eliminates smoking. We also were able to use various legal arguments to ban smoking even in strictly private homes in some situations. If there is a custody battle going on and there's a kid or two involved, one parent smokes, one doesn't, courts will order the parent who smokes not to smoke. We've had drifting tobacco smoke. We've had other situations. So right now, we're not doing that at the moment, but it is underway. And I would suggest you contact groups like GAS, Group Against Smoking Pollution, Action on Smoking and Health, maybe even the American Cancer Society.
Okay, we have a comment here that a Professor David Gordon Wilson started the Mass ASH chapter at MIT, and he wrote a book, The Men's Kick Line, that mentions you.
Okay, well, I thank you. And by the way, let me remind everybody out there, if we don't get enough questions, there will be a pop quiz. So
we have about 5 left
the more
here.
the better.
We have a question from Mina Marifat, who is on the board for the MIT Club. And she says, legal activism has been a means to express dissent against prevailing power structure. What is the most challenging action needed if the election is challenged? We, of course, live in DC, so we think about the election a lot.
It's kind of hard to answer that broad question in that way, because we don't know what the results will be. We don't know where it will be challenged, how it will be challenged. Is it going to be mail-in ballots? Will it be fraudulent ballots? Will it be miscounting? Will it be Russian interference? We simply don't know. So the answer at the moment, by the way, is that there are literally hundreds of lawyers already actively engaged in litigation involving the upcoming election on both sides, that is Republicans and Democrats, and perhaps a few libertarian lawyers floating around. And I'm sure there will be more unless the election is so open and shut, clear cut, and so on that nobody can really deny it. But to give a broader answer, I think I would say this. One of the things which I teach my law students, which I think is the central tenet of being a legal activist, is to search out what is the most effective way to attack a particular problem. Again, it could be smoking, it could be obesity, it could be auto safety, it could be airline safety, it could be governmental corruption, it could be voting fraud. At any given time, there are organizations like the one I headed, which probably could bring dozens of actions to advance their particular cause, what they are interested in, what they are established for. They have to pick out the one which is going to be the best, the one or two, because they only have limited resources. To do that, what I teach in my course in legal activism is we use some tools. I mentioned, for example, legal leverage. Well, think back to your high school days. I think it was Archimedes who said, give me a lever, a long enough lever, and a fulcrum on which to put it, and I can move the world. Well, in legal terms, what we do is we look out and we say, we want to find something where the input, what we have to do to get it going, is small, and where we have a potentially very, very large output. You don't want to bring legal actions in court, usually, because those tend to be long, expensive, drawn out, and so on. What we try to do is find those where you can bring the action, put only a little bit in, and get a lot out. And my 3-page letter with an 8-cent stamp mailed from a cruise ship, which saved millions of lives and billions of dollars, is a great example of that. So that's one of the things we look for. Secondly, we look around for what we call legal judo. In ordinary judo, what you want to do is you use your opponent's strength against him. You take what he's throwing at you and you spin it around. Well, in legal judo, we try to do something like that. Ordinarily, if you are the plaintiff, you have an uphill battle. You're against somebody big and powerful, the tobacco industry, the broadcasting industry, the fast food industry, whatever it may be. And if you go up against them directly, you're likely to lose. So what we try to do is take what would ordinarily be a disadvantage and turn it into an advantage. Very quick example. When we were challenging a major airline because it refused to hire blacks, or at least discriminated against blacks in hiring, if we had gone to court, we'd still be in court. What we did is we sat back quietly and waited until that airline had a merger. The merger had to be completed within 60 days. Then we filed a complaint with the agency which was approving it, saying, don't approve it because they discriminate. Well, guess what? The delay now works on our side. Legal judo, they gave up immediately and changed their policy. We also look for what we sometimes call guerrilla law, LAW, a little bit like guerrilla war, but the idea is multiple unexpected attacks. And the example which I use for my law students is, suppose there's this great big elephant, and you got to get him to move, and you're a tiny little bug. How can you possibly do it? And that's us, of course, if you're going up against a drug company, an oil company. Well, you'd fly around, you'd find the most delicate place on him, and you'd sting him. But sometimes the elephant still doesn't move. He may move a little bit, move around. So you now fly around again, and you find the next most delicate spot, and you sting him there. And sometimes even that doesn't work. And so he rolls over a little bit and covers up, and then you find the third spot. And if you keep stinging even the biggest elephant, eventually he's going to get up and he's going to move. So we sometimes will file multiple actions. We will file a complaint with an agency. We will file a petition for rulemaking with an agency. We will file a request for hearings before the Congress. We will go into court. We will seek discovery. And sometimes synergy applies. The whole is greater than the sum of its parts. So I can't answer your precise question, but I've given you some guidelines which can apply across the board. Students pay a lot of money to learn all that.
Okay, we have a question from Zena, who says, in addition to the regulations.gov, which is a terrific resource, specifically for non-lawyers who are seeking to change existing laws in a state or across the country, is it possible to be taken seriously without a law degree or a law student, or do you have to have one of them on your side? If federal agencies are not excited to create waves, is there a better strategy to start by suing an individual entity on a state level rather than maybe going full federal?
Okay, I think as a general rule, going with and working through an agency is much better than trying to go through court. Court tends to be expensive. Lawyers are expensive. And if you represent yourself, we have that old saying, you have a fool for a client. Agencies are designed to maximize your input. They are designed so that you don't have to be a lawyer, but you come in with a basic complaint or idea or suggestion. This ad is deceptive for the following reason. And if you're a biochemist and you show, for example, that that's why it's deceptive, that's fine. So you go to the agency. You don't have to be a lawyer. Remember, all of the cases that I gave, all the projects I gave you, these were law students. They didn't have an ESQ after their names. Yet, I remember very vividly law students sitting there cross-examining industry executives. I remember, for example, going back to the soup case, the head of the Federal Trade Commission walked in and was taking his seat. Under his arm was a newspaper. Front page of the Wall Street Journal had a big article saying, this case, the soup case, was going to be the decisive case saying whether or not the FTC was going to be taken seriously or would remain what they called at the time the little old lady on Pennsylvania Avenue, which was not a complimentary term. Well, we had placed that article in there. But the law students, 2 second-year law students, stood up before the 5 members of the Federal Trade Commission and made their arguments as law students. So you don't have to be a law student. There are places on the internet where you can go to learn. And one resource you might want to check is check your local law school. Many law schools have clinics where students are learning by doing. And if they have an environmental clinic and your problem is environmental, they can help you. If they have an anti-discrimination clinic and they are in business, they might be able to help you if that's your kind of problem. If I can again take a little bit of an aside and explain a key difference. Clinics usually are limited in the kind of problems they can take on because they represent real clients. They also have to have very close supervision, again, because they represent real clients. What I did is I basically set law students loose on the world. They represented themselves. They didn't have to have that kind of close supervision. They didn't have to have this very limited scope of what they could do because they were representing themselves. And this created a very, very real advantage. And to show you the contrast, we had at that time a clinic which represented battered women. It was actually battered people, but usually they were women. And the students would, every year, they'd get a batch of new battered women, and they'd learn, and they went out, and they got protective orders and consent decrees and so on. They were very good at it, and they learned a lot. And then next year, a new batch of women came in. My students approached it as legal activists. They said, what can we do to change the system? And they brought a petition for rulemaking to the DC Police Department. Now, they had no procedures. They'd never heard of it. Nobody even knew what it was. But we said, why don't you adopt the new rule? At that time, the policy was if police showed up in the department and the evidence that there was beating of somebody, usually, again, the woman, they'd separate them, they'd let her go off to be with a girlfriend, get him out of the house, maybe a little lecture, but nothing more. They didn't arrest because they believed that that would only make the guy angrier, and next time he'd beat her up even worse. We suggested, based upon new social science evidence, that they start arresting. And they did it. So they adopted our idea, they started arresting them. Now it's across the country. They watch Cops, you see almost every night. So we didn't just put a Band-Aid on the problem, solve it for 12 or 24 women who are beaten every year. We actually made a long-term change because what they found, is that arresting has a much greater deterrent effect than anything they were doing before. More questions?
Okay, we have about 7, so we had some come in. From SC Chu, on August 19th, Advancing Justice and AAJC filed an amicus brief in U.S. versus Tao, providing significant evidence of racial profiling against Asian Americans and immigrant scientists and researchers. And they want to know what your view is on the benefits of filing an amicus brief.
Amicus briefs can be very, very important for a number of reasons. Under our legal system, which is, by the way, very different from what the civil system the French and other countries use, where the judges are much more active. Our system, the English system for us in Canada and Great Britain, Australia, New Zealand, our judges kind of sit back. They're referees. They're not supposed to be activists. And so we rely upon what we call the fires of controversy, the two sides presenting the arguments and the facts and the issues. But sometimes one side is outclassed. Sometimes neither side wants to bring up something. Sometimes there are facts or legal arguments or issues or policies which neither side happens to know about. So this is a classic example where an amicus can come in and bring these to the attention of a judge or a decision maker. Also, many organizations use them simply to show support. We call them show the flag briefs, because basically they say in this discrimination case, well, women's issue, or the women's group, and the Hispanic group, and the black group, and the this group, and the that group, and so on. They all support it. But amicus briefs can be important, and you don't even have to be an organization. Again, to give you a quick example, you all remember back within the last year or two, we had situations where kids were being kept locked up on the border because they had a new policy. They weren't releasing the parents. The administration argued they had to keep the parents in detention, and that meant keeping the children in detention. Well, again, I put on my MIT hat, and I sent an amicus to the judge, and I pointed out that's just not true. We have bracelets, GPS tracking bracelets, which can be used to track these people, make sure they show up for their hearings. We have more advanced things. We have voice recognition. So you could pick up your cell phone, computer calls the guy talks into the cell phone, voice recognition, picks it up, you know he's there. And at least so far, the judge has not approved something which I thought would be a pretty bad decision. So maybe the amicus was working. Back to you.
You just mentioned activist judges. Andrew Frankel asks, what's a good way to counter people who criticize activist judges, and what exactly is an activist judge?
Well, one definition of an activist judge is the guy who rules against you. It's an adverse comment. And some judges are just the opposite, that they refuse to bend old rules, even though they may no longer apply, that they may be out of date, that they may have no solid legal basis, that they can't think beyond the very narrow box, and I'm not sure that's good. An activist judge is one who tends to push a point of view very, very strongly, even to the point of possibly bending, or in a few rare cases, even breaking rules, and that, I think, is not what you want. And there are ways that we can counter it by making different arguments, by creating publicity and public pressure, by filing complaints against the judge with various judicial commissions and so on. But I think in the end, what you want is a judge which is halfway between. You don't want one who is so stuck in the mud that he can't see that you have a completely new situation here, that what they rule, well, my own case with the copyright. Back in 1904, they refused to copyright a player piano roll because it was too mechanical. And they said, well, it's just like computer programs. And so I had to point out, no, a computer program is not like a player piano. It's very different, and that's how they copyrighted it. So you want a judge who's willing to think outside the box, who's willing to be more adventurous. A lot of the cigarette suits were pushing the envelope, but you don't want one who is going to go too far over, and that's a hard balance to try to reach and maintain.
So we have a question here from an anonymous attendee saying, why can't we sue the bastards to protect the environment?
We do. I mean, when I started ASH, there were no environmental organizations. There's a little guy out on Patchogue, Long Island, who was bringing suits because they were spraying DDT, and not a single person would help them. There was only one organization, and they slipped them a little bit of money under the table because they didn't want to be accused of suing somebody, litigating. It was a bad word. Today, there are dozens of environmental organizations out there litigating. When I used to bring environmental lawsuits, I'd send out the word, and I'd be deluged with people who wanted to join. Everybody wants to jump on. And if you are an organization which has members, you have an organization where you're seeking contributions, you want to be able to get in on all of these. You want to be able to say to your members, yes, we filed an amicus brief here, we were parties here, we filed this complaint, we filed this comment, so on and so forth. So sure, it's happening, but just because some people don't understand this, not all public interest organizations, the legal activists, are what we would call liberal. There are many who are conservative, there are many who are libertarian, there are many who are very concerned about religious liberty, which I think you probably say is more on the conservative side than the liberal side. It is a technique which is now being used very, very widely for a wide variety of different causes. And with my law students, I always define it that way. Public interest means anything beyond a very narrow interest. You can be pro or against abortion, pro or against gun control. You want to represent witches or nudists or whatever. As long as it's more than a few people, not yourself, that's public interest.
We have a couple questions I'm going to combine here. We have somebody asking your thoughts on how to strategize to preserve the Affordable Care Act, or separately, how to preserve access to contraception and Roe v. Wade. And then another question kind of similarly, as some of these social issues are becoming really political, how do we see legal activism facing a stronger challenge from the status quo? Maybe kind of how is that going to play out?
Okay, on the first two, again, it's very, very hard to answer in the abstract. And that, again, is why I have this course, and I train my students so that when they go out and they join an environmental organization, or auto safety organization, or a women's rights organization, or LGBTQ organization, they can then try to figure out which of the dozens of different actions that they might bring might be most useful. But on the broader question, I think it's much easier today than it was when I started or when many of my students did their thing. When I brought my cigarette action, the southern states dominated the Congress. They grew tobacco. The tobacco lobby was the most powerful lobby up on the Hill. There was no way to get around them. And yet, by going to an agency, we were able to get anti-smoking messages on the air. We drove cigarette commercials off the air. We got the first drop ever in cigarette consumption in the U.S., something even the Surgeon General's report couldn't do. Many of the other projects which I've outlined to you were things which couldn't have been accomplished through Congress because of these powerful entities and so on. Today, you do have regulation.com or .gov, I guess it is. It's easier to attract others to your cause because you can go on the internet, you can search on the internet, you can look up articles about a particular problem. By doing that, you can sometimes find lawyers who are interested, or other plaintiffs or organizations. You have the publicity, which you use as a weapon. And again, it's much easier. I remember when I was getting publicity, I'd hop on my bicycle in Washington, D.C., and I had a route, and I'd drop off my press releases at the Washington Post and the New York Times and 3 others, and that was about it. Today, I can sit at my computer here, and I can send out, as I did today, a press release to over 1,000 people. So it's much easier to do it today, believe it or not. Yeah, hard things are happening. You see violations every day. But the thing I'd like to stress is there are alternatives. You don't have to go out in the street. You don't have to necessarily engage in violence. You don't have to necessarily be unlawful, not even sitting in the dean's office. Law can be very useful, very effective, but you got to learn how to use it. I can't do that in 5 minutes.
We have a follow-up question from Zena, so they must have a specific question in mind here. But they ask, if a state agency takes you seriously when they reach out, is there a certain type of letter that is maybe worded legally or a strategic letter? Does it make a kind of difference in what kind of approach you use that would make them listen to one person over another on the same issue? What gives you the best edge?
Okay, again, we call that course legal writing, and it takes our law students the whole term. But I think the answer is you want to avoid being overboard. Don't call somebody names. Don't say they're stupid or idiotic or they're biased or they're racist or whatever. Present your argument in simple, clear language. One of the problems that I've encountered, one of the reasons I think I've been so successful, is that often you have to take what is a complicated concept, whether it's a statistical concept or a concept of physics or chemistry or biology, and present it to a judge or to a regulator who may not have even gotten out of high school science. So you got to really present it very, very, very simply. But I think a letter which spells out the problem as clearly as you can, which then spells out what you think would be the solution as clearly as you can, it's often a good idea to have 2 or 3 alternatives. The best solution to problem X would be do ABC. If you can't do that, well, fallback might be D, E, F. And if that's impossible, hell, you at least ought to do H, I, J. And remember that agencies, good agencies, are designed so that they listen to the public. Some of them are no damn good at all. They won't listen to you. They throw you out. I've been thrown out myself, even though I think I write a pretty good legal document. But the whole reason we set up discrimination agencies or environmental protection agencies or clean air agencies or clean water agencies is to work with ordinary, common, everyday people. Many of these people don't even have a high school education. Many of these people, English may be a second language, a third language. They're supposed to be able to work with you. At the DC Human Rights Organization that I work with in DC, you send in a very simple complaint, and then in the old days you go visit, now you do it by telephone. They sit down and the counselor talks with you and they walk through it and they ask you enough questions, and based upon that, they then file a complaint, assuming you have a valid cause, and they'll be able to work with you. And by the way, if you speak Spanish, they speak Spanish. And when I was back working on behalf of the deaf, we got them to be able to work with deaf interpreters. Excuse me for my cigarette cough. It's not the topic.
Okay, we have about 10 minutes left and about 4 questions. So we have somebody ask, can an employee sue a specific federal agency for failing to follow requirements of Section 508 of the Rehabilitation Act? Very specific question here.
Okay, I believe the answer is yes. In many situations, you can file an action against an agency. Often you can also file the action against an individual within an agency. But it really depends upon the agency and the statute. I think there are 2 cases on this in the Court of Appeals literally as we speak. Again, to kind of build on that, let me give you an interesting example. Under the DC Human Rights Act, you can bring your action not only against the entity, but against the people at the entity who are cooperating, who are aiding and abetting. So, for example, we got smoking banned outdoors and indoors everywhere on our campus when I threatened to bring a legal action, not against the university, but against the idiot who refused to do something about smoking on the campus. Scared the hell out of him. Another time I went after a paper in DC. They were running ads for ladies' nights. Now, it was a club in Virginia. In Virginia, ladies' nights were legal. In the district, they were not. I didn't bring the action against the newspaper. I brought it against the editor and the advertising manager and 1 or 2 other people as individuals. So they had to come in under the rules without any lawyers. They were on the hook themselves for the damages and attorney's fees. And nobody wants to do that, particularly when they're facing somebody like me who's a lawyer. So they gave up. They agreed to stop doing it. And that can be a useful tactic. So you can sue individuals, you can sue the agency. But to be honest, it is difficult to sue an agency. They have many legal protections. They also have a hell of a lot of lawyers. And so it's often not no battle. Remember, you want to look for legal leverage. And often suing a particular agency is not the best way to do it. The first 2 weeks that I spend with my students in legal activism, they come in with a problem and they usually say, I think we'll sue, blah, blah, blah. And I'll talk them through it. Gee, that isn't really very likely to be effective. It's going to cost an awful lot of money. It's going to be an awful lot of work. Isn't there another way to do it? And the example I give them, remember Don Quixote. Don Quixote ran around looking for the biggest windmill, and he charged right into that big windmill, and he get all chopped up. Well, in many ways, public interest lawyers are like Don Quixote. They're looking around at those windmills. Often they're going to pick the biggest windmill, and they're going to make a direct challenge. Let's charge right into it. And guess what? They get chopped up. They never succeed. I say, no, look around for a medium-sized windmill. Look around for one that has a crack in the wall and a loose brick. So if you just pull out that little brick and give it a little kick, the whole thing comes tumbling down. That's an effective legal activist. Again, we can't teach it in 5 minutes. That's what I teach my law students. Back to you. By the way, I'll stay here as long as anybody wants to. As long as we get off by the time the big debate gets on, I'm cool. It's up to you.
All right. We have a GW Law School alum here, Alex Haliasos, who says he missed taking your course when you were on sabbatical the year he wanted to take it. Is it possible to audit your course via Zoom or remotely now that we're all at home?
Well, at the moment, I'm not teaching the legal activism course. And in fact, I'm not even teaching this term. It's not clear yet whether I'll be teaching this term and or whether or not we'll be doing it over Zoom. So stay tuned, talk to the record office when spring comes around, and make your choice. Love to have you. Sorry you missed it.
We have a question, another political question. Again, it's just a habit of where we live. Is it possible to get rid of the Electoral College and go to direct election of the president?
Sure, I almost did it. Remember I told you that back in law school, I was still a law school student, I had to invent a new mathematics to deal with what we then called weighted voting. What had happened is a professor of mine wrote a law review article. He thought weighted voting was great. And our law review was going to publish it. They came to me and said, well, is his analysis right? Weighted voting? I said, hell no, go up and tell him. He said, no, you tell him. And that was in the days when nobody dared set foot in a professor's office. And so I walked into his office, and his name was Big Jack, and he was 6'6", and he towered over me, and I'm a big guy, and he scared the hell out of me. And when I told him I thought his math was a little bit wrong, he threw me out of his office and said, you're so goddamn smart, get your own law, write your own law review article. So I did, and that's how the Banzhaf Index was created. Well, after I got finished with weighted voting, I tried analyzing the Electoral College, because it was widely believed that the citizen voters in the less populous states had a big advantage. They had more voting power. But when you do a rigorous mathematical analysis, it turned out that it was the citizens in the larger, more populous states that had the greatest advantage. And back when I did the analysis, New York had more than California. Their citizens had more than 3 times more voting power than citizens in some of the other states. That turned into hearings before the House and Senate. It turned into a bill before the House and Senate to abolish the Electoral College. It came damn close. It was the last time it was close. We almost made it, but it probably would require a constitutional amendment, although there's another process working whereby what is called a state compact. If enough states get together and join this compact, in fact, you can take an end run around the Electoral College. You don't have to pass a law. You don't have to go through, you don't have to get approved by 2/3 of the states and passed by Congress. Any more?
Yep, we got 3 more. I'm going to do the short one, hopefully first. Victoria asks if your book will be for the general public or more geared towards lawyers.
If my what? I didn't get the whole
Your book, the one you're working
on.
on.
Would be, I guess, an expanded version of everything I've done tonight. I'll tell you tall tales and true. I'll give some inside stuff on how some of this stuff happened, like, for example, how I wound up typing the whole goddamn petition with the last group and so on, some of the other funny things that happened. But then I will try to provide advice for both laymen and lawyers, because I think that anybody who has a powerful position, every lawyer has power. Unlike virtually any other group, more than journalists, doctors, everybody else, we can go into court, we can sue the federal government, we can sue the highest officials, we can go after big corporations. I mean, we went after McDonald's. So we have the power, with it comes responsibility. But if you happen to be a CEO or high up in an organization, if you work in academia and you're a physicist or a chemist or biology, whatever else, you have power. And I think with that power comes responsibility. You don't have to be a lawyer to do these things. It's better in many cases if you can find a lawyer, but there are lawyers who are activists in many areas. And one of the things you can do is look at news articles, use a Google, news.google, look for articles about your particular problem, see if there are any lawyers quoted, see if there are any organizations quoted, then contact them and say, hey, I got a great idea, why don't you do this? And that's one way to get help. But again, you can always file your own.
And do you know when your book is planned to be published?
Nope. Every time I sit down to try to write it, I wind up suing somebody else. Right now, I'm working on a couple of COVID problems, by the way. Interesting, again, for my MIT colleagues, I figured out that a lot of people who have COVID and have to go on into a hospital may have maybe what we call respiratory distress. They cannot breathe, cannot survive without breathing assistance. But they may not necessarily need a full-fledged hospital ventilating machine, which costs tens of thousands of dollars and requires a lot of skilled people to work it. You can use what we call a simple CPAP machine, kind of thing that millions of people use at home just because they snore. It does the job. In many cases, we don't need a full-fledged ventilator machine. and you don't need anybody skilled to operate it. And right now they're having a major problem in places like Africa. Of course, they don't have many ventilators at all. In many cases, they may not even have much in the way of electricity. But I was able to work on this idea, and our Food and Drug Administration, also the Australian version of our Food and Drug Administration, has now approved and recommended using CPAP machines for people with COVID who don't necessarily require a full ventilator, but would die without ventilation assistance. Every time I get wound up in one of those, book gets pushed aside.
Great, and I have had a couple of questions. This is being recorded, and we will be posting it probably tomorrow on ColumbiaDC's YouTube page, and I will also send out the link, so you will be getting a recording of this. Okay, a couple more questions here. Tom Neal says, thank you for everything that you have done. He hated smoking on airplanes, and says, if there were a Hall of Fame of legal activism, what cases would be in it?
Oh, that's tough. I would certainly put some of my law students in them. I would put some of the ones brought by Ralph Nader. I would put the one by my colleague who brought those DDT actions out in Patchogue, Long Island, and wound up starting environmental, first major environmental organization. And it depends upon how broadly you want to define them. Certainly, some of the actions establishing harassment for women as being illegal, or extending Title IX, which was originally designed to deal primarily with women's athletic teams, to include date rape. Those would go on there. It's hard to do it. Maybe when I do the book, I'll try to come up with 100 top ones. We'll see.
Okay, and our last question here in the typed questions from an anonymous attendee says, on racial matters, there's longstanding pushback in the public sector in efforts to pair racial justice with economic parity. Do you have any suggestions for rulemaking on achieving economic parity with white Americans?
Again, that's a very, very broad topic, but I will mention something I did just in the last week. There is a very interesting, to me, frightening study, which says that black babies, if they are treated by a white physician rather than a black physician, are 3 times more likely to die. So it has nothing to do with any inherent problems of race and sickle cell anemia, nothing to do with what they get at home or anything else. Take a random bunch of black babies, put them in a hospital, 50 treated by white guys, 50 treated by black guys, 3-to-1 ratio. Now, it's going to be very difficult, bordering on impossible, to find out exactly what any one physician did or didn't do, which might have led to the death. But again, this wonderful DC Human Rights Act says that you can file a complaint if the effect or consequence of something is to discriminate on the basis of race. So I have outlined a legal action where you go in, you don't identify any, you go to one big hospital, for example, which may have hundreds of kids over the last couple of years. If that applies at that hospital, and I don't know that it does, but if it does, if the 3-to-1 ratio works out, you can go after that hospital and simply say, whatever the hell you guys are doing, black babies treated by white physicians are dying at 3 times the rate of those treated by white physicians. You're going to pay big damages. We're going to do discovery. We're going to look at all the records. We're going to look at all the emails. We're going to make you clean up the game. And that's one simple step in that general area. But again, I don't know enough about that area, but I'm sure there are dozens of other similar actions which can be brought.
Yep. Well, this is Comrade Ron. Thanks, Professor Banzhaf, for a great education. It was truly educational, and thanks for your time. As Miyako mentioned, we're going to post, after processing, we're going to post the video on our YouTube channel by tomorrow, and we'll send you an email with a link. If there's no other comments or questions, thank you all.